Hello, everyone. In Decatur, Alabama, on the banks of the Tennessee River, there's a large manufacturing facility for food manufacturing run by Wayne Farms. And the Occupational Safety and Health Administration issued a citation against Wayne Farms under the machine guarding standard when one of its employees reaching into a breading machine got his sleeve caught, which pulled his hand in, leading to a serious injury. We're going to talk about the Wayne Farms case, the machine guarding standard, and what it means for employers as a result of a review commission decision on that case today on the June 16th, 2021 episode of the OSHA 3030 with Manesh, Rath. Hello, everyone. I'm Manesh, Rath with the OSHA 3030. I'm an attorney here at the law firm Keller and Heckman in Washington, D.C. I am an attorney who practices in the field of occupational safety and health law. And I'm joined today, and I'm very grateful to be joined today by my colleague and friend, John Gustafson, who is one of our OSHA attorneys and also engages in other areas of law, including TSCA, FIFRA, California's Prop 65. John, welcome. And thank you, by the way, for joining us today.
Thank you for having me, Manesh.
It's been a few months, and so I'm grateful that we're able to work on this together. And I think we got a great case today.
Absolutely. And yeah. Yes, always nice to be on the OSHA 3030.
Well, it's always nice to have you. Let's talk, John, about what we're going to talk about.
Sure.
So we talked about the Wayne Farms case, and I think that if we break down some of the things we're going to talk about, maybe we can get into it.
Right. So today we will be discussing that opinion. We'll start by giving some background on the machine guarding OSHA standard. We'll then talk about the facts of the Wayne Farms case, both what happened in the facility, and then also important testimony that was given during the hearing in front of the administrative law judge, and that is the level below the commission. Then we'll talk about the commission's decision on appeal and focus on the opinion's main question, which was whether the employee access to the hazard that caused the injury was reasonably predictable during normal operation of the machine. We'll then discuss the meaning of this opinion, and I think it's very meaningful in terms of what is expected of employers, and then some takeaways for employers that are watching. And finally, Manesh, we're going to then go to the off the record segment.
That's right. This is a new feature that we're putting into the OSHA 3030 starting with 2021. After the program is over, we will shut off all of the recordings that we use to rebroadcast this as a podcast and on YouTube. And when the recordings are off, it is just a live webinar, unrecorded, where people can pre-submit questions in the days leading into the OSHA 3030. We'll also keep the question and answer box open in case somebody has a question. But this could be about anything relating to OSHA, law. If it's a black letter law question that we can answer off the top of our head, we'll answer probably 2 or 3 after the OSHA program is done. That program we call Off the Record. We have 2, by the way, interesting questions that were pre-submitted by members of the community. One of them relates to OSHA just published its emergency temporary standard on COVID-19. And so we'll talk real briefly about addressing that participant's question. And then there was a decision that came out of a federal court in Texas relating to also COVID-19, where an employer required everybody at the workplace to come back to work with vaccinations as a precondition of returning to work. So we had one inquiry about that case, and I'm happy to talk about that one because I think that's incredibly impactful. So with that said, that's the off the record portion that'll happen at the end of our program. Let's get into, John, the Wayne Farms case, and let's start by just talking about the machine guarding standard generally.
Absolutely. Right. So that was the standard that was at issue in Wayne Farms, the machine guarding standard. And that standard requires employers to provide one or more methods of machine guarding to protect the operator and employees that are in the machine area from hazards. So if we think about what the standard is requiring, it's requiring a safety result rather than a specific type of guard for this machine. So OSHA is saying, we don't care how you achieve this result, but you have to protect your employees from the hazards posed by these machines. And so that is called a performance standard. And to satisfy or to meet the requirements of the standard, an employer has to identify the hazards that are specific to their workplace and then determine what steps are necessary to abate those identified hazards. And just as an employer has to do a facility-specific inquiry analysis, so too must the administrative law judge and the commission on appeal. They look at what was necessary in the context of the machine and the operation of the facility. And that's what the commission looked at in Wayne Farms.
Yeah, that's a great point. And the fact that it's a performance standard and not a specification standard makes the burden, I think, for the Occupational Safety and Health Administration a little tougher if they want to establish that a violation occurred, because once you acknowledge that the agency is trying to enforce a performance standard, there's a lot of leeway for how an employer achieves the end result that results in a safe working environment. In the case of machine guarding, a properly guarded machine. And so the burden for OSHA is to establish that the standard even applies, and then that it applies, that it was complied with sufficiently, which is I think, moving beyond the four corners of the standard itself to do so. So with that said, let's talk about what the elements are in an OSHA complaint and how to make a machine guarding standard. To begin with, John, should I walk through this?
Sure.
So to begin with, in order to make a machine guarding citation to establish a violation, the agency has to establish that the cited standard here, Section 212, the machine guarding standard, applies to the circumstances being alleged in the citation. Then OSHA has to allege that and establish that there was a failure to comply with the standard. So the machine guarding standard being a performance standard, I think this is a tough one. And this is, in this particular case, this is what the review commission focused on, is whether or not the employer in fact failed to comply with the standard. And then whether there were any employees exposed to the allegedly violative condition. It is theoretically possible for a standard to apply, for there to be a circumstance that is on its face not in compliance with a standard, but there might be no employee exposure, and thus a critical element of establishing a violation is missing, and OSHA would not be able to establish a violation in that event. And then finally, that the employer knew, or through the exercise of reasonable diligence, should have known of the violative condition. So again, you may have a violative condition that nobody has access to, and the employer, even through exercising reasonable diligence, wouldn't reasonably be expected to discover. And in that event, it is theoretically possible that a administrative law judge or the review commission might find that that was not a violative condition. So with that said, let's talk about the Wayne Farms case. Now that we've level set everyone on the elements that OSHA has to establish, and the fact that the machine guarding standard is itself a performance standard.
Right. So first we'll go through the what normally happens at this Wayne Farms facility, and then we'll move to what happened in this particular instance. So this Decatur, Alabama facility uses an AccuFeeder machine to bread its chicken on its production line 53. And this machine has is loaded with chicken, and then an employee pours flour through a hinged and latched metal grate into an enclosed hopper. So this grate has holes in it. The flour is poured through the holes, but the grate is both latched on one side and hinged on the other. And this latch can be screwed down so that the inside of the machine is completely inaccessible. Now, this hopping does not happen at the grate level. It happens well below the level of the grate, 2 feet below the grate. So for an employee to reach the hopping area in the machine, they would really have to make an effort. The facility, the Decatur, Alabama facility, has 3 shifts. So it runs for 2 daytime operational shifts. And on some days, when the days that the hopper is used, it will run for both of those shifts. And then it will be turned off at the end of the 2nd shift, and the overnight cleaning shift will begin. And this during, it's a poultry processing facility, so it needs to be thoroughly cleaned. The entire facility is cleaned, and the machine's automated cleaning function is turned on. And a part of that cleaning is to remove flour that adheres to the interior of the hopper as a result of its daytime operation.
This is interesting, and it's important that you talk about the shifts, because like many of the food manufacturers that I visited, and we represent a great many, we see that the 3rd shift is a cleaning shift where all the machinery is cleaned out. And the reason this is important is because this injury occurred in the 1st shift, and the employee said that he was reaching in to clean out the inside of the hopper of caked flour. But that really is the purpose of the 3rd shift cleaning crew, and that's elemental to the review commission's decision.
Right. So it raises the question, and we'll tackle this in a minute, but does flour adheres to the inside of the hopper? So can that flour wait until the cleaning shift, or must it be cleaned during the day, during the daytime operational shifts? But let's continue with the facts of what happened with this particular employee. So this employee, as Manesh stated, this employee was working that 1st daytime shift. He lifted the metal grate, which was unlatched at the time. So as we just talked about, the grate can be screwed down on one side, on the latch side, but it was unscrewed at the time. So opened the metal grate, he reached inside to clean the flour that was adhering to the interior. And while doing that, and his smock got caught by the paddles that do the hopping. So the paddles that ordinarily are jostling the chicken and the flour, breading the chicken, his smock got caught in there, and it pulled his arm and his hand down into the machine, at which point his injury occurred both to the arm and hand. So OSHA, after this injury, OSHA inspected, and they issued a 1-item serious citation alleging violation of the machine guard standard. And Manesh, even though a serious citation may carry a small monetary penalty, it could still have major consequences both to a company's operations and requiring substantial changes to their operation, but also to a company's competitive position when they're vying for bids.
Yeah, it totally makes sense for employers in many circumstances to contest even a single citation item with a small monetary penalty, because the penalty, as you say, is just the smallest fraction of the implications of taking a serious citation. So Wayne Farms did contest the citation when it was issued. This is an interesting case because we see that the employee in the 1st shift which is the shift right after the cleaning crew had come in and cleaned the machine, believed that he needed to remove some caking. And here we have an image that's somewhat illustrative of the machine itself. So there's a screw auger, and the product comes in and feeds through. And it's in that kind of machinery that the employee got his sleeve caught, pulled his hand in, and his hand was seriously injured. He later went to the hospital, by the way, and they performed surgery, and I believe he lost 2 fingers. So it's a serious injury. Well, the reason this is interesting is because the cleaning company, the cleaning crew had just come in. He believed that he needed to do so anyways to take some caked flour off. Many employees said that this wasn't a necessary task for shift 1 production employees. And he did so with his bare hand, without a tool, without any device, without shutting the machine down. He lifted up the guarding, the grate, the hinged grate, and reached in and with his own hand started to declump the flour product. When this went to trial, lots of witnesses came up and testified. Other employees testified that they'd received training and that they were told not to open the grate and never to reach below the level of the grate. When the team leader testified at trial, he testified that he had seen the employee in question stick his hand below the grate once before and told him, hey, stop that, don't do that, you're not supposed to do that. Another coworker said he'd also seen the employee stick his hand in the hopper in the past and also told him, hey, don't do that, you don't need to stick your hand in there. The employee himself was put on the stand, and his testimony was a little bit less consistent. He said that the employee training did not include any kind of training about not sticking your hand in there. He didn't know about it, and that he'd never been taught not to stick his hand below the grate. And he said that further, he didn't recollect being told not to. However, on the day of the actual injury, others testified that the first thing he said when he got his hand caught and coworkers came running towards him was, oh, you told me not to do this and I did it. What a mistake. I know you told me not to. And so that testimony is inconsistent. He certainly acknowledged that he had been reprimanded in the past. The question that the review commission focused on, and I think that this is substantially different than the question that the administrative law judge focused on, was really whether or not he needed to, in the normal course of business, clean the flour from being caked from the inside of the machine. Was it ever necessary for a first shift worker coming in right after it had been cleaned to remove the flour caked on the inside? Other employees had testified that even if there was sufficient caking to be addressed, that they were able to solve the problem by knocking on the outside of the hopper, maybe with a stick or other object, and it just sort of vibrates the hopper and decakes anything sticking to the product. So all of these facts, plus the fact that it had already been cleaned and he was a first shift worker, not a cleaning company worker or a cleaning shift worker, led to the review commission evaluating whether or not his access below the grate level was even within the normal course of business. And if it wasn't, the review commission questioned whether or not the machine guarding requirements applied were sufficiently complied with by the grate. So the review commission at the time of this decision, they had a full commission, which included Amanda Wood-Leahy, Cynthia Atwood, and the chair, Commissioner Jim Sullivan, who has since left the commission. John, let's talk about that commission decision.
Right. So the commission vacated OSHA's citations, but it did so on different grounds than the administrative law judge. So the administrative law judge, or ALJ, found that the secretary failed to prove that the employer had exposed the employee to the violative condition. Manesh, that was the third element of the citation that you identified. But the commission found the Secretary of Labor failed to prove the second element, which was non-compliance with the machine guarding standard. And the first question, as Manesh alluded, the question to this compliance element is whether the access to the hazard was or was not reasonably predictable in the normal operation of the machine. And that's in its context in the facility. And the commission found that the hazard was not reasonably predictable, and applied to the facts here. The commission found that manual cleaning of the hopper was not required during its normal operation. So in other words, the employee cleaned manually and did not need to do so, was trained not to do so, and that cleaning was not part of the normal operation, and so that the exposure to the hazard was not part of the normal operation or reasonably predictable. So the commission found that element was lacking, and based its decision on that element in part on the testimony and credibility findings of the administrative law judge and the hearing. And the commission opined that the injury resulted from the intentional idiosyncratic behavior of only one employee. So this employee's injury was caused by their own divergent practice and therefore did not meet the second citation element, non-compliance with the machine guarding standard. So let's talk. Yeah,
it all comes down to how the machine is supposed to be used. The commission said the non-compliance at stake right here in this case is whether or not the grate covering that covers the hopper was even required to protect employees from hazards such as those created by the AccuFeeder's auger or paddles or in-running nip pints. And the review commission said to make this determination, they were interested in whether or not the grate was necessary when considering the manner in which the machine functions and how it is supposed to be operated by employees. And as you say, this was a type of activity by the employee that was considered a deliberate, intentional, idiosyncratic, sort of non-compliant practice that went directly against training, directly against several reprimands. And I think that is an incredibly important decision by a very capable commission panel. Like the panel composition prior to this one, this is a panel of the review commission that sees through these issues and I think went straight to the gravamen of the case, and I think they did a good job of that. John?
Right, and this is not a commission that is always aligned. So when they are aligned, it's a powerful statement.
Yeah, I think that's right. They pointed out that the question of whether or not the hopper even needed to be manually cleaned during first shift seemed to be an important, pivotal threshold question to address. And the administrative law judge concluded that manual cleaning wasn't required during shift one. And I'll point out two things: the fact that it was shift one and the fact that we're talking about manual cleaning as opposed to a proper cleaning method, which would have involved not reaching your hand below the grate level. And they came to the conclusion that there was never an instance where employees were expected, requested, instructed, or trained to, in the regular course of business or operation of the machine, to place their hands below that level where the metal grate was. And that was 2 feet above any in-running nip points.
Right.
So let's talk about what this means. So this is an important decision. I think it's an incredibly important decision in the machine guarding standard. Yeah. And it's one of the few cases where the review commission has shed some light on this question, not within the auspices of the unpreventable employee misconduct defense, but rather whether or not this kind of idiosyncratic behavior really goes to the scope of the applicability of the standard in the first place, and whether or not that kind of idiosyncratic behavior is the kind of conduct to be guarded against in the machine guarding standard.
Right. So it really addresses, the opinion addresses the degree to which an employer is responsible for its employees' divergent work practices. What level of predictability is required here? Does an employer need to guard against any possible hazard that an employee could find themselves in, even as a result of their own divergent work practice that's idiosyncratic behavior? And the commission here really drew a line in the sand and said that employers don't need to, or they're not liable for hazards that are not reasonably predictable during normal operation.
Right. I'd say one last thing before we move on to this practical takeaway section that we always implement in the OSHA 3030, the section called What Employers Should Do. One last thing I'd say is this is a question of whether or not the standard was violated, or whether the Secretary of Labor can establish a violation. But as a question of best practice, where the machine guarding standard is concerned, there clearly was a grate. It had a hinge on one side, and it was designed, at least, to accommodate a screw to fasten it on the opening end. And that screwed end, or that latch end, was unscrewed. The screw was missing, I believe. So here we have a type of covering, or type of guarding, where if it's not frequently accessed, the screw should have been in place. Or at a minimum, we can say that that regular maintenance and observation and inspection is a practice that could have uncovered the fact that it was unscrewed. But if it's a hinged grate that is accessed quite frequently, there are other methodologies that can be implemented to achieve a good guarding practice, such as interlocking devices for the grate and the use of tools, which they did use. And so we're really focusing in the Wayne Farms decision on the question of law of whether this constituted a violation, given that the employee had no business and couldn't reasonably be expected to engage in that kind of repetitive conduct despite being told many times not to, rather than what would be a best guarding practice, where I think interlocking that grate would have been a practice that they could consider. With that said, let's talk about what employers should do. John, I think the first thing that I like to see is a hazard assessment where predictable hazards are identified, and that the employer documents what protections would address those perhaps reasonably foreseeable hazards.
Right. And then documenting training and work processes is another important takeaway here. We saw how influential the testimony about work practices was in the decision.
Yeah, I think that's right. So when you just take a look at machine guarding and lockout tagout, for example, and the training required to document for each employee when they were trained, what they were trained on, the content needs to be preserved. And I prefer, I think, as a gold standard, that there be some testing for comprehension. Maybe a demonstrative test is even a higher level of comprehension evaluation, and that be recorded as well. And then if there's multiple refresher trainings, that all of that be recorded and preserved. Here, as you say, there was plenty of evidence that the employees had been trained on how to do this the right way. The next thing I'd say, John, I think it's important to include a question of safety compliance when evaluating employee performance, that employees should be measured, at least in part, by their safety practices. And I think that this is consistent with OSHA's view that management and the safety culture has to come from the top down, come from management. But that the rank and file, every single employee has a role to play in safety in the workplace.
Right. And going along with safety compliance of employees, compliance with trained practices is reprimanding employees where they diverge when necessary, and making sure that that happens in writing. There needs to be a written record of any employees or any divergent work practice.
Yeah, John, that includes verbal reprimands. Even when you give a verbal reprimand, a manager or supervisor or foreman needs to make a record that a verbal reprimand was given, what it was given for, the date, etc. The question of whether or not practices that are trained and in the written policies are informally ignored needs to be addressed and documented. And you have to constantly preserve evidence that this is a living policy and not just one that you write, put up on a shelf, but don't practice on a daily basis. But that in part comes from the discipline, the monitoring, the walkthrough inspections, etc.
And then just updating these understandings, bringing this back to step one periodically. What are the hazards in the workplace? Are we doing everything we need to do to protect employees from hazards?
And then the walkthroughs on the daily walkthroughs, make sure everyone's doing it right. Well, John, you got the last word on today's OSHA 3030, and thank you again. We've been doing this for over 8 years, and all of our prior episodes are libraried on our website at khlaw.com. Please check them out. Many of them are still extremely relevant, extremely educational. So go through the library on a year-by-year basis, find topics you like, and you'll find that the slides, the sound are all recorded and available in self-executing files. Our next OSHA 3030 will be coming up in another 30 days. That's the title. We'll rebroadcast this episode as we have for the past 5 or 6 episodes, and we're trying to get more and more up on the library on YouTube. So when you go to YouTube, just do a search on Keller and Heckman, and you'll find quite a few of the OSHA 3030 episodes. We're all on LinkedIn. John Gustafson, I know you're on LinkedIn. I'm on LinkedIn. Our colleagues, Larry Halpern, David Servati, are all on LinkedIn as well. So please link in with us if you haven't yet. And we're going to rebroadcast this episode as a podcast as well. So subscribe to the podcast on your favorite podcast app, and make sure, please, to like or rate the program so that it's more easily searchable for others. Which reminds me of a request I make every episode. When you get the next invitation to the OSHA 3030, please forward that on to at least 3 other people. Even if you've already done so before, find 3 more people who are professionals in safety and health or in-house counsel in the corporate office of general counsel at your organization or at other organizations who might be interested in staying up to date on critical developments in OSHA law. Our next program will be in about 30 days, always on a Wednesday, always at 1 p.m. Eastern time. Next time, July 21. Our sister programs will be coming up the week before that. The TSCA and REACH 3030 are scheduled for July 14th, 2021. And if you would like to have another episode of the Fifth for 3030, send an email to John Gustafson. I'm sure he'd want to hear from you, what topics you might have in mind, and what kind of timeframes work for you. That's it for today's OSHA 3030. On behalf of everyone here at Keller and Heckman, I want to thank everyone. Don't go away. We're going to have the off the record session once we turn off the recordings. But on behalf of everyone at Keller and Heckman, I'd like to thank you all for participating and listening in on this month's OSHA 3030. John Gustafson, I'd like to thank you as well for being a co-presenter in today's program.
Thanks for having me, Manesh. It was a pleasure.